morning, everybody. Thank you for the introduction and a warm welcome from IAB Europe from Brussels. We are a proud partner of this second Ad Traders conference here in Hamburg. This was quite bold from the organizers because they are asking me to start the whole conference with a kind of a downturner and give you an update about the political situation in Brussels and to what extent cookies will remain in the future. And I think everyone in the room knows what that means for all our business models. But anyway, I think there is good news also, so I will be happy to give you an update. But first of all, perhaps some slides on, if the thing is working here, some slides on IAB Europe, because perhaps not everyone knows what this organization is about. Can you turn? Okay, thank you. So IAB Europe is the European trade association above all the IABs in the national countries you might know. So for example, in Germany, it's called BVDW. I saw that Arndt Groth will give the closing speech today. So IAB Germany, in fact, will be on stage as well. But there is 27 other IAB organizations around Europe, and IAB Europe is the association sitting in Brussels, trying to get the voice of the European digital industry towards the Commission and the lawmakers in Brussels. We are representing over 90% of all digital marketing revenues, which is quite impressive, as I think, and important nowadays. So, as I said, 27 associations across Europe, 41 corporate members, among them all the important companies across Europe, both European companies and US companies and other companies that are playing an important role, and more than 100 people across Europe working as, for the lobbying, for the policy part of the game. And you will see that it is important to have that workforce on the ground. Yeah, that's the agenda for 2012, Protect. That's the main thing I will be talking about over the next few minutes. The lobbying, the policy part of the game. But of course, as a trade association for the digital industry, we also have to take care for promoting the business, tell especially lawmakers in that case how big it is, how fast it is growing, and how important it is to act wisely in that field. And of course also to prove to ourselves, to advertisers, to the industry, to people spending their money in television right now, and so on, how good digital works to spend their money in the future. And just to give you one slide on how important the industry is, if you look at basic key factors about what digital is driving in Europe, there's a very interesting study that came out from the European Digital Media Association just recently, which tried to sum up all the turnover, the revenues driven by the digital industry across the 27 member states. And as you can see, it's 310 billion euro or 2.7% of the overall GDP. And if you take into account also, the kind of associated businesses around that, it grows up to close to 8% of all GDP across Europe. So if you ever talk to someone in the policy arena, for example, you should have that figure in mind. It's very important, and not to mention the growth factors behind those figures. It's a very important industry, obviously. So now let me talk about the downturner I promised to give you, and that is the current draft for a new data protection regulation coming from Reding's cabinet in Brussels. We saw the first draft in November last year, and we're currently discussing kind of you could call it a final draft, something that really, could be close to the thing that finally will be implemented. So I will just go, flip over some key facts. Many of you might know some details out of that, but I think everyone should be aware of the danger coming out of that. So, for example, I think you all know the e-privacy directive. We have been talking about that since 3 years, and everyone knows the threat and the ambiguity and all the unclarity coming out of that. And we're really happy to see that this remains, because this new regulation from Reading brings no clarity to what extent the e-privacy obligations will be covered or not. So that's unclear. And the first very important point is, we're all talking about data-driven advertising and the data-driven industry. And the main threat, as far as I'm concerned, from this piece of regulation comes from the fact that every kind of data is being treated as personal data. That's what this current draft says. And that means also in existing national regulations right now, but in this framework as well, that we need consent. For personal data, a much stronger legal framework has to be applied, and especially we need consent. So that would mean every cookie, every IP address, every piece of data you're using for your business model will be treated as personal data, and you will need explicit consent for that. And we really think that should be changed, because obviously the industry, the data-driven industry, is not running on personal data. That's part of our business, for sure, but there's also a huge part of the business which is running on data which does not have to be treated as personal, but anonymous or pseudonymous and so on. So this whole concept has to be introduced into the framework. That's a major requirement for change that we see. Next one. Yeah, the other point, obviously, regardless whether all data will be treated as personal or not, the kind of consent we have to get is a critical point as well. And this is, again, very hard, because the kind of consent has to be, it has to be documented. Browser settings cannot be treated as consent, and so on. So it will be very hard for businesses to get that kind of consent, especially digital and European companies. So just think of one of the affiliate companies around, how hard it will be for them to, if they would come up with a pop-up and ask consumers, are you okay if I'm setting a cookie now to track which ads you saw? You can imagine how many opt-ins this company would get. So this is really something that has to be changed and put into shape. The next thing is the right to be forgotten, something that Mrs. Reading seems to have deeply in her personal agenda, because she applied that in other areas before as well. And it's not the kind of baddest principle, because the general idea, it's also called data minimization or Datensparsamkeit in German, is that once you don't need a piece of data anymore, you should delete it, or should almost be automatically deleted. But on the other hand, especially in the digital field, we have a lot of automatic deletion mechanisms already in place, especially cookie deletion. So that's, again, something, if we would be forced into having explicit mechanisms in place to forget data, that would be difficult to implement. Profiling is important as well, because a lot of things are being prohibited that are currently clearly allowed. This is, I think, very important for any kind of scoring mechanisms and this kind of stuff, but also, especially as it is very unclear in its wording, it could be applied to many things in our industry as well. So any kind of scoring mechanism that an ad business is using to identify good placements or good consumers to show specific ads could be falling under that, and then it will be prohibited to go on. Lawfulness of processing, even if you get an opt-in, you might not be allowed to process the data because there are several restrictions in the law that describe when at all data can be processed. So that's another problem. And finally, there are some, of course, administrative burdens, and there's an imbalance of consent and processing, but that's rather formal stuff. You see, the main problem is, especially for this conference, we are all running our business based on data. Many of that comes from cookies, but also from other technologies, and that will be really changed or hurt if that regulation comes into play. So what that means for especially European businesses, as this will be a European framework, is that we might turn the European area into a kind of an importer of other technologies sitting in other countries if we go on with that restrictive set of rules for European businesses. And I think that's something really we should think over and talk to with our representatives on national and EU level. So rethink, obviously that's something, and I 2 slides later I will lay out when this will come into play and how long it will last and stuff like that. But that's clearly a framework for everything what we are doing until we will go into retirement. That's pretty clear, because this set of rules, once they will be applied across Europe, will remain and define the playing ground for the next 10 or 15 years, for sure. So we really should think about where we want to be with that, how much we want to influence that. We have to have European companies on stage in Brussels and influencing and giving the whole thing a voice. And of course, the associations, especially IAB Europe, but also other partners, are working already hard on fixing of many of the provisions I just have been talking about. And one of the most important points, especially for all you guys in the room, is that we as an industry should prove to policymakers, to lawmakers, that we treat that problem seriously. The problem of lack of transparency for consumers, too many cookies, where no one can really find out what all is about. We really have to change that, and that's why IAB Europe with other associations started this self-regulation process where all ads will carry an icon to show additional information. I will give you an example on that. It is extremely important, because that's not what trade associations will implement, that's what you guys in the room will have to implement over the next few months, that we can prove to the Commission, being seriously in that all ads, or almost all ads, will carry that additional new piece of information, which is the icon here in the upper right corner of the ad, which you will see, a standardized global icon, and we're very happy to say that we found a solution to get a worldwide license together with our US colleagues, so consumers will see the same icon across all markets and find a way to get additional information behind that. So if you click on the icon, you will get a standardized kind of page with background information, what is going on, which information is involved, how can I opt out, opt in, get additional information, and this kind of stuff. It's extremely important that we get that out and up and running over the next few months, so please be prepared and support that program. But there are also positive aspects of the whole thing, especially as it will be a regulation, which means the law that Reading puts on paper will be implemented as is in the 27 member states. There will be no translation into national law. And that means for all, because I think most businesses in the room are acting in a pan-European manner, so in many different markets. That means if that comes into play, we will have a standard set of rules over all European markets that will be applied, which is excellent because it's absolutely not the case right now. Of course, there's an improvement for users as well. So the kind of data and information and transparency that will be applied will be harmonized across Europe as well. And the whole data protection will be organized more independent and also in a standardized way across European markets. So there is a chance of getting a level playing ground in terms of data protection regulation out of that, which will be a great thing, you know, because having data protection in good shape is one of the most important things we have to solve if we want to run a data-driven business, obviously. So finally, the question is, you know, when will this be in place? When do we have to expect the changes coming out of that? And that is really interesting, you know, because currently we are in 2012, we are discussing kind of a final draft that seems to be close to a real law that can be put into place. But as we are looking forward for the first reading, the second reading, and then after, you know, negotiations backwards and forwards, the thing will be put into place, and then we have a 2 years period until the law really is going into effect. And that means not before 2016, which is, I think, a very important information for many of you in the room. I must say I was surprised by that as well, because we as a digital industry tend to think, you know, 2013 is the future, 14 is already far away, so, you know, what the hell should we think about 2016? But it is important because the facts are dealt with now, and that will be here in play, and then it will stay for many, many years and define how we can do business in this field. And as I said, there will be no national implementation. So once this has been agreed here and it goes through, it will replace existing national law. So Telemediengesetz for the German guys and BDSG and all these things will be replaced by that law. So it really affects what you guys are doing in your business. So finally, I thought, you know, perhaps you might be, besides all the political stuff and all the dealing and negotiation, you might be interested, you know, in two things. What are the real risks for you in your business today and in the future? And what can you do about it? You know, how can you influence the situation? So what I see is that there are two kind of concrete risks you have to face with your business. One is coming out of the e-privacy directive. The e-privacy directive has to be translated into national law. Actually, we are already behind schedule in many member states, and it's actually kind of existing law right now. And as many of you know, it's quite unclear in the e-privacy directive whether you need an opt-in or not for cookies. So there are different interpretations out. And not surprisingly, the data protection authorities do interpret the law in a different way than, for example, the industry association does. So you can expect data protection guys to start suing companies for not being compliant with the law soon. So, for example, the guy from the UK or Mr. Koonstam from the Netherlands announced that they will start going after companies that are not compliant with the law soon. That's something we will see over the next few months. I'm pretty sure about that. Of course, you know, it's not the government, but it's the data protection authorities. So it does not mean that you're not compliant, but it will cause problems, and we will have to deal with that. I think we're in a good position, but it will be one of the risks we have to face in the near future. And the other thing, obviously, is, you know, a little bit more into the future, coming out of the data protection regulation, the thing I have been talking about over the last few minutes. If that is being implemented like it is drafted right now, we can all leave the room and go home, you know, because data-driven display advertising will be dead after that. If we need consent for cookies like drafted in the paper there's no room for what most of you guys are doing right now. So that's really something we have to face and act. And answering the question what you can do, I think don't sit and wait is a very important thing. I've just been to Brussels a few days ago together with Matthias. I think he's already in the room. Matthias Ehrlich from United Internet and other business leaders from across Europe. And we were talking to many representatives of the Commission, and they clearly said, we want to see more guys involving in that process, more countries, more businesses, give us a voice, tell us that you care about what we're doing here, because we don't see so much activity around. So that's very important. Talk to your policy guys, talk to your associations, be active and make a voice, tell the people that you care about these developments. And the other thing is we have to, as a whole industry, act as a responsible industry. So really show to the public and the policy guys that we are treating that seriously, that we are supporting the self-regulation program, and that we will show impressive rollout of the icon and all the mechanisms that should be in place defined by that program. So that's my key message. Don't take that easy, please. I'm pretty sure you don't do it, but it's not just waiting for some guys in the associations to deal with it. It's too dangerous, too serious. What we're talking about, it will define the playing ground for the next 15 to 20 years. And it is being in negotiation just right now. So get involved and support what we're doing with the self-regulation, please. Thank you very much.